All right, my friends. I just pressed the Let's Go Live button. Let's see if these post-Christmas tubes are going to connect themselves. You know, sometimes the one light bulb will just kind of go awry. Hopefully that doesn't happen with the tubes today. Hopefully the audio's coming in loud and clear. Hopefully you're having a beautiful Tuesday, my friends. It looks like they are connecting. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Donald Trump filing an opening brief out of the D.C. Circuit Court of Appeals. And we've been following these for quite some time. Trump is in the middle of a bunch of different appeals. And we're going to go through a big one because if he's successful here, then it's going to be the end of the cases, right? If he is successful on presidential immunity for acts that are within the official job description of the president, then he's going to be pretty clear from a lot of this stuff. And we'll see what happens with the Fannie case and so on. But we know that we're going through this appellate process. We know that Jack Smith tried to leapfrog over the Court of Appeals in the DC Circuit. And SCOTUS last week said, sorry, Jack, Merry Christmas. Your case is not being fast-tracked. You're going to have to go back down through the appellate process, and that is it. And so we're back down at the lower level court in the, above Chutkin, but below the Supreme Court, and we're going to be looking at the opening brief. We have some reading to do, but it's some good stuff inside, and so we'll see what Jack Smith is going to have to respond to. We've got a couple clips. Joe Biden was out talking about presidential immunity. This guy is saying that absolute immunity is going to be rejected. And by the way, I agree with that. Nobody's arguing that Trump has absolute immunity. That is not what the argument is. It is that Trump has presidential immunity for acts that are within the perimeter of his official duties. So we'll go through that. And then we've got James Trusty. This guy's former Trump counsel. And he is going to be explaining his take on the Supreme Court stuff. And I always like listening to James Trusty. I think he's got some good analysis. So we'll see what he says about all that and more in the first segment. It's a nice opening brief, and we'll go through it. Then we're going to turn our attention to what's happening in Maine, northeastern America. We're going to go up there. I'm sure it's cold up there. But Maine is trying to get Trump thrown off the ballot. And they're going the same way that they did in Colorado. And in Colorado, they already had what they called a trial, and they had some other things there. But what is happening in Maine is they're saying, we don't need to relitigate any of that stuff. Okay, what happened in Colorado is done for. And so there's an issue, there's a principle in the law called collateral estoppel and issue preclusion. And Maine is saying, basically in Maine, the Secretary of State there, you just have to follow Colorado. You don't really have to litigate any of this again. And so we'll go into that. Then we've got a couple clips from Gavin Newsom and from Lindsey Graham. He gets asked, what really he thinks is appropriate in terms of Trump's statements and so on. And so that will all be what we get in the second segment. And I'm keeping an eye on the audio. Audio sounds good. Everybody, I see it looks hopefully good. All right. We've also got Trump in the last segment. This is a spicy segment. Trump says Jack Smith and the DOJ enemies should go straight to hell. And we're going to go through that. Now, I'm interpreting that as, when their life expires through the ordinary course of things and, all of that. Like, this is not, anything that I think is a call for something bad. But we're going to go through the statement because the left is going to have a meltdown over this. FBI is already investigating threats against the Colorado judges, and Lisa Monaco is saying there's an unprecedented rise in threats against the DOJ. And so they're going to tie it all back to Trump. Trump is fighting this gag order, and so he's pushing the bounds of free speech. And so we're going to go through that in depth here today. And let's pump that mic up just a smidge, see if that helps a little bit. And then we've got some reaction to this. Okay, Karl Rove is saying that Jack Smith is not I'm sorry, that Trump is in more trouble because he had another bad phone call. And so let's see what he had to say. You remember that guy from the Bush years? Man, it's been some time since we have heard from Karl Rove. Then we've got Jen Psaki. She had a show this holiday break, and so we'll see what she says. She's saying Trump is going to come in and eradicate the civil service. And so we've got a lot to get to, as you can see, my friends. It is a beautiful Tuesday. Welcome back. I hope you had an amazing Christmas and holiday. And so we've got some business to attend to today. We had a great members-only stream this morning at watchingthewatchers.locals.com, where we're able to debrief a little bit about our Christmases. And, you know, I know some people are back to work. I know some people are still enjoying the holidays. Yeah, I got Santa was very nice to me. I got some new polo shirts, which is going to be a lot of fun. So that will be fun to, you know, change things up here on the show. I tend to keep my polo shirts a little couple years past the expiration date. So that's exciting. We also had an amazing time with the family. And so I hope you did too. We had incredible food. Mama Govea went absolutely bananas. And it was just amazing. All sorts of leftovers here for the rest of the week. And so we got to spend some really great time, had some great conversations around the dinner table. And I am grateful to our family. I'm grateful to you, my friends. I hope you had a beautiful Christmas. And I'm glad that you're back and we're here ready to go. We've got the website, of course, at robertgovea.com. which if you want to read any of the PDFs, they'll be up there after the show. If you want to sign up for the daily newsletter so you get all these segments just synthesized and delivered to your inbox, it's right over there. You can check out the new shop as well at robertgovea.com/shop. Grab a hat, grab a t-shirt, a great way to support the show, and they're nice quality, good stuff that we'd love to see out there sporting. So check it out, robertgovea.com, and we'll see you there. And so without any further ado, let's get right into it because we've got some reading and some business to attend to. Donald Trump and his defense filed their opening brief in the D.C. Circuit Court of Appeals, and we've been going through this appellate process for quite some time. We know that Jack Smith just got the Merry Christmas backhand. Sorry, Jack, you can't jump over the line here in the Court of Appeals. You have to go and file the appeal through the Court of Appeals, and then you can hit our court. And I'm wondering why this button is not working over here. My apologies. I have a show error. I have a technical glitch here. Anyways, we'll figure that out later. So, anyways, point is, Trump is now filing this in the Court of Appeals, and we've got some reaction from some other people, including Trump's former attorney, James Trusty, on what happened with the SCOTUS denial. So we'll go into this, but let's get started with the Court of Appeals argument. You see, oral argument is currently scheduled for January 9th. The court is the District of Columbia, the D.C. Circuit, for the United States of America, Donald versus Donald J. Trump. This is the opening brief of Donald Trump. The usual people here working on behalf of Trump, John Lauro and Todd Blanche, are here submitting their filings. And here is what they say. The parties, of course, we know. We've got Donald Trump. He's being prosecuted by the United States of America. We've got a bunch of amici curiae. These are friends of the court. Oh, look, it's J. Michael Luttig. That's probably Judge Luttig. Great. Disclosure and cases under review. We know we've got a bunch of other stuff happening here. We're going to fast forward through the table of contents, fast forward through the table of authorities, and get right into the meat and potatoes. Let's see where it starts. There it is. Donald Trump's defense writes to the Court of Appeals in the D.C. Circuit. They say, "Dear judges, Merry Christmas. During the 334 years from 1789 to 2023, they say no current or former president had ever been criminally prosecuted for official acts. Now, that unbroken tradition died this year, and the historical fallout is tremendous. The indictment of Trump threatens to launch cycles of recrimination and politically motivated prosecutions that will plague our nation for decades to come and likely stands to shatter the very bedrock of our republic, the confidence of the American citizens in an independent judicial system." And this is something that I absolutely agree with. We've been here lamenting the downfall of our justice system. Very concerned. We already know the executive branch is in the trash. We already know that Congress is like a 6% approval rating on a good day. The last thing that we had was our judicial system that hadn't been too politicized. Okay, we had, of course, abortion cases and the regular, ordinary course of the judicial, ebb and flow. But what we've seen ever since January 6th, ever since the Democrats got in charge, they have just ransacked the independence of the judiciary, right? That takes decades and centuries to build up. For people to think that the judiciary is legitimate, that is evaporating overnight. This has been something that's been worked on since the beginning of our country, and now with just a couple years of damage, it's basically gone. And I don't know that it's ever going to come back, to be perfectly clear with you, which is why this next election is so important, because whoever controls the Justice Department now apparently is going to control the country. It's like capture the flag. You can now just indict your political opponents and go hog wild, and there's very little recourse. Now, we're going to see if that goes to fruition. I think it's going to backfire on them. But the point is, they're the ones who crossed the line. But here is what Trump's defense says. Under our system of separated powers, the judicial branch cannot sit in judgment over a president's official acts. The doctrine is not controversial. It was treated as self-evident and foundational from the dawn of the Republic, and it flows directly from the exclusive vesting clause of Article 2. In 1803, Chief Justice Marshall endorsed this. He wrote in the seminal case, you probably heard about it, called Marbury versus Madison, a case that's widely considered in law school to be the case that established judicial review, which is a critical thing. And then we're just, kind of flushing all that down the toilet, that a president's official acts, quote, can never be examinable by the courts. Okay, a Chief Justice, he put it in that case. A president's official acts, quote, can never be examinable by the courts. Because that's his discretion. If the courts can say, sorry, President, you're not allowed to do that thing, which is within your discretion, well, then that's going to mean that the court is really the president. They're the ones who get to decide. Okay, if Donald Trump had to do whatever Liz Cheney said right after January 6th and call her, hey, Liz, are you happy with my response? She's the president, not him. If Trump has to go and call the National Archives, hi, can I please have my documents now? My classified documents, please? She says, I'm sorry, Mr. President, you have to fill out the form. Who's in charge? The president or NARA? All right, this is what we're talking about. And these people keep trying to topsy-turvy that. But they say, the structure of our government, the text of the Constitution, and its early commentators, common law immunity doctrines, our political history, the Supreme Court's analogous immunity doctrines, and the policy considerations rooted in the separation of powers all dictate that no president, current or former, may be criminally prosecuted for his, quote, official acts unless he is first impeached and convicted by the Senate. And so every time you hear one of these dementoids on, MSNBC saying, first of all, total immunity for the president, total immunity. You say, no, first of all, that's not what they're arguing. They're arguing immunity for official acts. You see that in italics. But then secondarily, the recourse, which they all forget about, is you just impeach him and convict him. Okay, so if the president does something insanely criminal, like that's actually a crime, it's a no-brainer. You just impeach him. It's, a unanimous in the House. Boom, right over to the Senate. You get maybe 3 holdouts. They all say, this guy's a total criminal. Right? Because the political consequence is there. And once that happens, then boom, it's fair game. Indict them wherever you want. Indict them in 35 states for all I care. But you got to go through the process. So they say, nor may a president face criminal prosecution based on conduct. And Trump, by the way, was acquitted by the United States Senate. The indictment against Trump, they say, is unlawful and unconstitutional, and therefore it must be dismissed. Now, of course, we know the jurisdiction. The district court, which is Judge Chutkan, she denied Trump's claim of presidential immunity and double jeopardy in a bad filing. Trump filed a notice of appeal, and here we are. Now, here are the issues that we're really wanting to dive into and answer these questions from the Court of Appeals. Question 1, whether the president has immunity from criminal prosecution for official acts. In other words, those acts that fall within the outer perimeter of his official responsibilities. Okay, so the president is here. You've got, let's say this category, which is like absolutely articulated powers. Okay, like the president can clearly it's going to look like a Judge Engeron here in a minute. But we've got this is the absolutely, like clearly the president's duties. Then you have stuff that's out here that's maybe a little bit more, like it's not as explicit, it is implicit, right? You've got stuff that, well, there's a really good rationale that the president can do this because the Constitution says explicitly that, and so we can logically defer to this. And then, similarly here you have another, operation here. And we're asking ourselves, okay, this is the outer perimeter. Maybe this is like a little gray area here. Maybe we got some questions on this. We don't know, but that's what an executive does. An executive is having to, execute in new and novel situations. We ever had a country, an election where, half the former CIA rigged this with propaganda? We ever had situations where you've got massive evidence of fraud, not even on the day of the counting of the votes, but on the changing of the rules outside of the state legislatures that has the constitutional authority to set the rules. We had secretaries of states and judges all across the country changing deadlines, changing signature requirements, the whole thing. So, all of this is new and unprecedented, and Trump, in facing a new and unprecedented situation, is investigating these things. And yeah, maybe we haven't been in a situation before where the election was clearly rigged and we were censored in the run up to the election. But that's the outer perimeter. And you know what? I want my executive to enforce fair elections in this country. So I would say that is clearly within the Engeron, not outside the purview of the presidency. So that's question number one. Now, question number two, whether the impeachment judgment clause and the principles of double jeopardy prevent a president who's already been impeached, which is, you think of it like the analog of being indicted, and then acquitted by the Senate for the same or closely related conduct, right? So do they have to impeach, then convict in the Senate? Trump obviously was acquitted in the Senate before they indict elsewhere. And so here is what they say. All right, Court of Appeals, just so you know, here is the statement of the case, telling us that on August 1st, President Trump was indicted. We know these counts are obstruction and conspiracy charges. 4 counts based on allegations in his efforts to dispute the outcome of the widely questioned presidential election. The indictment charges that President Trump, with different crimes that are, they say, are acts of political speech and advocacy. They're charges, but that's what they are, saying that he's just disputing the election outcome after the campaign had already ended, performed while President Trump was in office. Campaign's over. Trump is literally the president. It is political speech, they say, and that's a crime. Now, the indictment alleges 5 types of conduct, all which they say are literally quintessential presidential acts. So they're within the outer perimeter, clearly. First, they say, President Trump made a series of tweets and other statements about the outcome of a federal election, contending the election was tainted by fraud and irregularities. All true. Now, second, the indictment alleges that Trump communicated with acting attorney general and officials in the DOJ who were responsible for investigating these crimes and possibly appointing a new acting attorney general. Guess what? Appointing an acting attorney general, that's the job of the president. Investigating election crimes, that's the job of the DOJ. Bill Barr didn't do much good at that. That is a division under the presidency. So that's a presidential act. Third, the indictment alleges that President Trump communicated with state officials about the administration of a federal election and urged them to do their dang jobs with extensive information from his perspective. And that's his mindset. Okay, that's for him to decide. Liz Cheney can say it's not relevant, or Bill Barr can do the same thing. But he's the president. They didn't get elected because their judgment is garbage and crap and they're not qualified. So we don't really care what their judgment is. Fourth, the indictment alleges that President Trump communicated with Mike Pence. Wow. So the president talks to the vice president. You're kidding. Is that a crime? Says maybe it should be for this administration. If they're gonna charge everybody for this type of stuff, like that's a crime. Okay. Well, what's Kamala? What's her status? Attempted to communicate with other members of Congress similarly, right? All presidential stuff. And fifth, the indictment alleges that other individuals organized slates of alternate electors from 7 states to provide a justification for Mike Pence to question and count the votes. All of that, right? Those are the 5 categories, which is basically just regular election stuff. Anyways, that's the statement of the case. Now, Trump's defense continues. They say, here is the status. On October 5th, President Trump filed a motion to dismiss the indictment. He said he had presidential immunity. He said it extends to immunity from criminal prosecution for a president's official acts. He argued all 5 classes of those conducts are inside the outer perimeter of the responsibility of the president. On October 23rd, he also filed a motion to dismiss. He said, the impeachment clause, which is in the Constitution, and the principles of double jeopardy, which is also in the Constitution, say that Trump has been already acquitted and indicted for the same crime. That's double jeopardy. That's a no-no. On December 1st, the district court, Judge Chutkan, issued her memorandum opinion, and they say that Chutkan wrongfully held that a former president has no immunity for official acts while performed in office, which is an insane ruling. So the president can be charged with crimes for his official conduct in office and without even being impeached, right? So there's no impeachment mechanism there either. So 50 DOJ or 50 attorneys general or state level prosecutors like Fannie can all just decide to go indict Joe Biden under this standard if they had, any political stones to do it. Now, the court did not address, Chutkan, whether any of the conduct alleged in the indictment falls within the scope of his duties. The district court also incorrectly held that neither double jeopardy principles nor the impeachment clause prevent the prosecution of a president who has been acquitted. So that's Judge Chutkan, brilliant legal scholar in D.C., who is just twisting and perverting the law for her own ends without considering the long-term consequences of this, because this is it. Stopping Trump is all eggs in the basket, man. It's break glass in case of emergency. The traditional judicial system is gone. It is now a tool of a politically motivated enterprise. Trump's defense continues. Here's the summary of the argument. They say, President Trump has absolute immunity for his official acts as president, and the indictment from Jack Smith alleges only official acts, and so it must be dismissed. They say 7 considerations mandate the recognition of presidential immunity from prosecution for official acts. First, criminal immunity has deep roots in the separation of powers. Look at the Constitution, Article 2, Section 1. It tells us the president is vested with executive power. The judicial branch may not sit in judgment, criminal or otherwise, of the exercise of that power. Otherwise, the court is the president. As Chief Justice Marshall wrote back in Marbury versus Madison, and this is like law school starts basically with this case in con law, and you really put a lot of emphasis on this because this was a critical juncture in the country. Like if the court didn't get itself integrated into the process, then the whole 3 branches might have gone topsy-turvy. The court may not have had enough power, and so it's kind of seen as like almost like a miracle of the courts, that they got some power and then the other branches kind of recognize it a little bit. And it's this very delicate balancing act that Judge Chutkan and the Democrats have absolutely wrecked. And the president's official acts can never be examinable by the courts. Okay, they figured this out in 1803. They were a lot more intelligent than what we have now. They say, second, the text of the Constitution through the impeachment judgment clause presupposes criminal immunity. It's in there. The clause dictates that a president may be criminally charged only if the, quote, party convicted is convicted in an impeachment trial. They put that in Article 1, Section 3, Clause 7. It says, party convicted. Trump was acquitted. They say Alexander Hamilton reinforced this understanding by writing in the Federalist Papers that the president may face criminal prosecution only afterwards or subsequent to impeachment and Senate conviction. You want a political prosecution layer to make sure it's not political. It's a safety valve. Okay, this person was convicted by his own party, right, in the Senate. So that means he's really bad. So then we pull him out. Okay, he's already been convicted. Now hit him with everything you got, states and feds. But that didn't happen here. President Trump was acquitted, not convicted, by the Senate after an impeachment, so he retains immunity for his official acts. And third, early commenters on the Constitution, including Chief Justice Marshall, George Washington's Attorney General named Charles Lee, Alexander Hamilton, Justice Joseph Story, one of the most cited justices in the country, maybe the world, and others, confirmed that a president's official acts are not examinable by the judicial branch, right? They don't get to say and substitute their judgment. Neither does Congress. Fourth, at common law, immunity from criminal prosecution was far more central to the concept of immunity than immunity from civil liability. So civil liability is kind of a subsidiary of criminal prosecution. Saying here, the prospect of senior officials facing, quote, criminal charges before a possibly hostile judiciary was the chief fear that official immunity was designed to prevent. Supreme Court talked about that back in 1966. Fifth, the 234-year tradition of not prosecuting presidents for official acts, despite ample motive and opportunity to do so, provides powerful evidence that the power to do so does not exist. Perhaps the most telling indication of a severe constitutional problem with this, quote, wholly unprecedented prosecution is, quote, a lack of historical precedent to support it. That's a 2020 case. They say six, analogous similar immunity doctrines for legislatures and judges, which are also rooted in a separation of powers, support criminal immunity for a president's official acts as well. Legislative immunity prevents legislative acts from being made the basis of a criminal charge, right? So if they have legislative protection, why doesn't the executive? Excluding cases of bribery, which were long prosecutable at common law, judicial immunity shields a judge from indictment for any act done by him sitting as a judge. Otherwise, the person who gets elected as like the local prosecutor is the most powerful person in the whole entity. They just prosecute whoever they want. I'm just going to prosecute all the judges who oppose me, and I'm just going to prosecute all the Congress people who oppose me, and I'm just going to prosecute, right? It's kind of obviously insane. So president's official acts are equally, if not more so, immune. And seventh, policy considerations rooted in the separation of powers support immunity, saying the president handles especially sensitive duties. The presidency requires bold and unhesitating action. Threat of prosecution in the future risks crippling that, lest the president be harassed by hundreds of prosecutors like Fannie and Tish in many enclaves throughout the country. Now they say, given the existence of criminal immunity, the scope of immunity should extend to the outer perimeter of the president's official responsibilities. And applying these principles, all 5 types of conduct alleged in the indictment fall within the outside perimeter of Trump's duties. So he should be immunized. And again, they're all going to say on the left that this is absolute immunity. And that's not what anybody is arguing. You see this word official? This has been used over and over again, but they want you to think that he can just, like he's a total tyrant. That's what he's arguing. It's not what he's arguing at all. And by the way, he's already gone through their due process and he was acquitted on it. That's why they're upset. So in addition, the impeachment judgment clause, according to the Constitution, it mandates reversal here because this incorporates a double jeopardy principle. A president who was acquitted by the Senate cannot be prosecuted for the acquitted conduct. They already were on trial and they won. The clause's plain meaning, its historical context, and its decisive weight of authority from key commentators all confirm that a single unelected prosecutor lacks authority to second-guess the judgment of the United States Congress, the people's representatives who are there. Fannie can just indict. Merrick Garland can just bring in an unelected prosecutor who's not even affirmed or appointed by the presidency or confirmed by the U.S. Senate. Jack Smith, just bring him in, and then he can just wreck the election. Like, he can just indict the president's political opponents. That's the type of process that they want in this country. So they tell us more about the argument in front of the Court of Appeals. They say the prosecution of President Trump, the entire thing, is barred by presidential immunity. It's like a force field that immunizes him. Now, they're going to cite this Fitzgerald case, the Nixon case, I believe, from 1959. They say this was the quote from that case. In view of the special nature of the president's constitutional office, they said a current or former president has, quote, absolute presidential immunity for civil damages for acts that fall within the outer perimeter of his official responsibility. It's a pretty powerful quote. So the question would be, why would that not extend into criminal domains? They say, in addressing whether this extends to immunity from prosecution, this court should look back at the Constitution, look at its text, its structure, its original meaning, look at the common law, the historical practice, look at the Supreme Court's precedents and our immunity doctrines, and please, court, think about public policy, all of which I'm sure they'll explain for us here. Now, all these authorities point in the same direction. The president, in this case Trump, had absolute immunity from criminal prosecution for acts within the outer perimeter of his official responsibility. So it was in the job description, and it was his official responsibility. Now they say, we know the separation of powers requires this. And I think this is important. First, they tell us, as emphasized in the Nixon-Fitzgerald case, the doctrine of presidential immunity is rooted in the separation of powers. The president operates and occupies a unique constitutional scheme, and absolute immunity is predicated on his official acts. It's incident to his unique office. Under the doctrine of separated powers, neither a federal nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts. Those are the presidency's alone, not anyone else's. We elected the president, not you, Liz. This grant of authority establishes the president as the chief constitutional officer of the executive, entrusted with supervisory and policy responsibilities at the highest of echelon. The president's unique status distinguishes him from other executive officials. And this is a point I've been making here for a long time. You've heard me belabor this point. But the president is the commander-in-chief. The president has the opinion clause power. The president has the pardon power. Okay, these are all very unique things that are to the president and the president alone. So when they say no one's above the law, literally he is. Like I hate to say it to you, but read it. It's there. The immunity of the president's official acts and from judicial second guessing has been treated as self-evident and foundational since the dawn of the republic. Chief Justice Marshall wrote about this in Marbury versus Madison. He said, hey, by the Constitution of the United States, the president is invested with certain important political powers, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and to his own conscience. Like that's a big thing for the courts to say at that time. Like that's given the president a lot of power. Now, the acts of such an officer as an officer can never be examinable by the courts, because you're substituting the courts for the presidency. And so it's like a moment of tremendous restraint even for Marshall and the courts to find this. It's like, whoa, we really can't do much, we can't substitute this. Like, we're not going to convict him on that stuff. Justice Story agreed, citing Marbury for the proposition that the judicial branch lacks authority to sit in judgment over a president's official acts. In the exercise of his political powers, the president is to use his own discretion, is accountable to only his country and to his own conscience. Okay, the people who voted for the person can decide what to do with that person. We get to decide. We don't get some special interest groups funded by George Soros who get to remove him from the ballot and decide for us. Or Jack Smith being appointed by Merrick Garland via Joe Biden to come and decide the election for us. They don't want us to make the decision. They don't want Trump to be held accountable to the country because the country's not going to hold him accountable for a 4-hour riot, which was orchestrated, in my opinion, as a security failure, allowing this to happen, essentially. And don't take my word for it. Listen to Stephen Sund, former Capitol Hill chief of police, who makes that argument. They say the president and his decision in relation to these powers is subject to no control, and his discretion when exercised is conclusive, because that was the role of electing that person. Thus, the judicial branch cannot require the president to exercise his executive power in some judicially prescribed fashion. Justice Scalia was concurring on that one, saying that an attempt on the part of the judicial department of the government to enforce the performance of the duties of the president might be justly characterized in the language of Chief Justice Marshall as an absurd and excessive extravagance. Otherwise, the courts are in charge. So they tell us Congress is the legislative department of the government. The president is the executive department. Neither can be restrained in its action by the judicial department. That's what co-equal means. It's incompatible with his constitutional position that the president is going to be compelled to personally defend his executive actions before a court. It's crazy. But we're doing that right now. The same principles, they argue, foreclose a criminal prosecution of a president for his official acts. Now they continue. The impeachment clause also presupposes immunity. Second, the text of the Constitution presupposes criminal immunity. For example, the impeachment clause, in it, it says that judgment in cases of impeachment shall not extend further than to removal from office. So Congress is only going to punish you to get you out of office. But the Constitution says this, Article 1, Section 3, Clause 7. I don't know that Chutkin read it. But the party convicted, ED, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. It's as clear as day. You got to be impeached. Then if you're convicted, you're subject, after the ED, to additional punishment. But Trump was acquitted. They don't like that. So because the Constitution specifies that only the party convicted in the Senate may be liable, a president who is not convicted may not be subject to criminal prosecution. Antonin Scalia wrote that. Shout out, Ray, you rest in peace. Now, as Justice Alito also recently noted, the plain implication of this clause is that criminal prosecution, like removal from the presidency, is a consequence that can come only after the Senate's judgment. And that is in a case where Alito is dissenting. Now, this is how Hamilton explained this. He wrote this in the Federalist Papers. He said that a president is at all times liable to impeachment, trial, and dismissal, but any punishment must come only by subsequent prosecution in the common course of the law. Any other punishment, right, needs to come after the actual impeachment and conviction. Thus, as the Supreme Court has often stated, impeachment, not criminal prosecution, is the principal check against a president for malfeasance in his official duties. That's the tool that we have. But that tool didn't work for them, and so they needed to invent new ones because they're cheaters. Now, early constitutional authorities even confirmed this. We know Alexander Hamilton wrote a lot about this. Marbury and General Lee also wrote about that. Not Robert E. Lee, but General Charles Lee, Attorney General. And they also talked about it. Common law supports this as well. The Supreme Court speech and debate cases make this clear. They say there was a privilege of legislative immunity that was not born of a desire to avoid private suits, but rather to prevent intimidation by the executive and accountability before a possibly hostile judiciary. Protection of the presidency from other political factions and a potential hostile judiciary is also reflected in the case law. We regard immunity as being rooted in separation of powers. So civil immunity without criminal immunity is like a lock without a key, a bat without a ball, a computer without a keyboard. In other words, it's not especially sensible. Now they tell us that Democrats have wrecked 234 years of history, saying Fitzgerald also consulted the presuppositions in our political history. Here are the facts, Jack Smith. From 1789 to 2023, no president was ever prosecuted for his official acts, despite centuries of motive and opportunity to do so. They say Trump is the worst ever. The worst ever, really? Now, the 234-year tradition of not prosecuting presidents for official acts strongly supports the existence of immunity. For example, American history abounds with examples of presidents who were accused by political opponents of committing crimes through their official acts. These include, among not many others, John Quincy Adams. You remember the corrupt bargain. He appointed Henry Clay as Secretary of State in exchange, what they say, I think is for the presidency. That's from the presidential election in the corrupt bargain. President George Bush, he made false claims to Congress, that Saddam Hussein possessed stockpiles of weapons of mass destruction. Obviously, that wasn't true. Thousands of people were killed as a result of that. Thousands were dead. Okay, we had the Capitol Hill police shoot and kill a woman named Ashley Babbitt on January 6th. We had Roseanne Boyland beaten and die, and others were killed there. But thousands were killed and went to die as a result of George Bush. And what about President Obama when he authorized a drone strike that targeted and killed a U.S. citizen and his teenage son, also a U.S. citizen? Is that any due process there? Is that a crime? How come he's not being prosecuted by a special counsel for killing an American citizen, two of them, via a drone strike? Trump didn't do that. Trump said fight like hell on a rigged election, and that was enough. In these cases, the president's political opponents vehemently accused that president of criminal behavior for his official acts. And I grew up, man. I was in, I remember after 9/11 with all the Bush stuff. Remember, Cindy Whack Job out there, and they were, all of them were demanding prosecutions, right? And they were all just saying that this was absolutely criminal. And, maybe they're right. Turns out maybe it's right. Maybe they are. Maybe they should have been indicted. I mean, if this is the standard, we're just going to start indicting everybody. It's like, okay. The theory was that you don't do that. Okay. The theory was you give the executive the benefit of the doubt. Maybe that's a mistake. But in each case, those outraged political opponents, they eventually came to power, but no president was ever prosecuted until this year. The Democrats and the DOJ created and shattered an unbroken tradition of not exercising the supposed formidable power of criminally prosecuting a president for official acts. Despite ample motive and opportunity to do so over centuries, it implies the power just simply does not exist. Now, they say that the lack of historical precedent coupled with the breadth of the authority that the special counsel now claims is a telling indication that the authority does not exist. They tell us that other immunity doctrines also support criminal immunity. We've got legislative immunity. Congress has immunity. There's judicial immunity. Sitting as a judge. If you're sitting as a judge, you're not going to be indicted for doing stuff that's within the purview. Likewise, legislative immunity. They've got it. A doctrine rooted in common law. If it's within your official act, you're immune from that. Cases where prosecutors have brought criminal charges against judges for judicial acts are exceedingly rare, as we've seen. The district court concluded there is no judicial immunity from prosecution for judicial acts, but this is incorrect, as is what Judge Chutkan said. So Judge Chutkan cited this, and they say she cited this wrong. Sorry, Judge. Read the case. At common law, judicial bribe taking, or bribe extorting, taking a bribe is not a judicial act. Clearly not. So sorry, Judge. Bad case law. We also got other policies that support this. The president has especially sensitive duties that they need to take care of. Under the Constitution, we've already recognized that. Supreme Court has also said unequivocally the president needs to take bold and unhesitating action. That's why we have a presidency. Crippling and deterring executive action is a concern. If a president can have a bunch of prosecutors nipping at his heels, then he can be harassed by political prosecutors who are bringing vexatious actions. Saying the district court and her reasoning, Judge Chutkan's reasoning, is just not convincing. It's not. The district court disagreed with our analysis. She said it's not convincing, however, Chutkan simply failed to address many of his arguments. So its own analysis erred. Chutkan said that no court has ever accepted presidential immunity from criminal prosecution for official acts. But no court has ever addressed the question. That's why, Judge, it's a new thing. You guys shattered this. As noted, the 234-year tradition of not prosecuting presidents implies that they don't exist. So Chutkan's like, well, we've never seen anything like what you're asking before. I can't believe you'd even ask me for that. We've never seen anything like that before. And you're like, yeah, hello, Judge. It's because it's never happened before. Hello, wake up. The district court reasoned that the absence of an express provision in the Constitution granting official immunity implies that no immunity exists. But that's strange, because that would mean that the civil suits that the Supreme Court have already found the president does have immunity from, then I guess the Supreme Court is wrong. Is that right, Judge? No, you're wrong. Fitzgerald upheld absolute presidential immunity from civil liability for official acts in the absence of explicit constitutional guidance. And so they say, moreover, Chutkan's logic, if you can think there is any there, would invalidate other well-established immunity doctrines that are not already well spelled out. We know what Alexander Hamilton said about this. We know that a lot of this has been universally accepted until this year. And the district court misapprehends all of the historical and legal context. Judge Chutkan has a difficult time with this. In 1973, in the year 2000, questions arose about whether a sitting president might be criminally charged for acts that included private conduct. President Nixon's alleged involvement was in a range of potentially criminal private conduct, and Clinton's alleged perjury and obstruction of justice in a recent private lawsuit was also based on unofficial conduct. But the legal issue addressed is whether a sitting president enjoys complete immunity from any kind of criminal indictment, even for private crimes. The question whether a sitting president has complete immunity from criminal process is distinct from whether it's process for immunity based on official acts. So we're distinguishing between different categories here. Going through their analysis, and the Office of Legal Counsel wrote a memo, and they tell us, carrying on, that Chutkan has made the argument that if she grants criminal immunity here, it would lead to perverse results. This is a dumb meme that you've heard a lot on MSNBC. They say presidents can escape the punishment for official act crimes in marginal cases, right? This is the Trump can just murder everybody before he leaves office, and then he's immune. They say the memo addresses very similar concerns about potential under-enforcement and concerns, and they conclude that the concerns do not outweigh the needs of the president's office and functions, saying the Constitution establishes a powerful structural check to prevent political factions from abusing the formidable threat of criminal prosecution. And under the Constitution's balanced approach, a president may be prosecuted, but only if he is impeached, tried, and convicted by the Senate. And so the Constitution opens the door to those prosecutions, but it requires a strong political consensus. It requires the participation of the political branches, including a supermajority of the Senate and the Republic's traditional cooling saucer before drastic actions can be taken. Which is why they wanted this to go so fast when Trump was right after January 6th. They went fast because they didn't want people to think about it. Accordingly, the Supreme Court has repeatedly emphasized that impeachment, for which Trump was acquitted, provides the principal check to deter a president. Now, the mere possibility of under-enforcement in marginal cases does not mean the president's criminal immunity evaporates. Every structural protection of the Constitution creates the possibility of under-enforcement, but that's a feature, not a bug. We're trying to stop this from political hacks, and it worked for 234 years. The district court reasoned that the Supreme Court largely rejected similar claims, but Nixon addressed a far less serious threat to the presidency. This is much more serious because these are official acts and it's a criminal indictment, and they're seeking imprisonment directly against the president himself. Now, they carry on. They say the district court emphasized the strong public interest, you've heard this line too, in criminal proceedings. But when it comes to the prosecution of a president, the Constitution, they say, strikes a balance that gives grave weight to those interests. It allows a president to be prosecuted for purely private acts and even for official acts after he was impeached and convicted. The district court had no warrant to rebalance what the Constitution has already balanced, saying that she says, Chutkan says, despite other vehement disagreements in the Fitzgerald cases, all 9 justices unanimously endorsed the denial of criminal immunity with respect to former presidents. Not so, they say, Judge. The majority in Fitzgerald merely noted that the exercise of jurisdiction held warranted over presidents to vindicate the public interest in an ongoing criminal prosecution, and it recognized that there is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions. But it didn't extend all the way to whether criminal immunity exists for criminal prosecutions. And the concurrence supports that, they argue. And fast forwarding through some more case law, they're citing a bunch of case law, as you can see, citing the OLC. They say that Chutkan is relying on some other things that are wrong. And they make in subsection C here another argument saying that the alleged conduct in the indictment falls within the scope of Trump's official responsibilities. It's within the hula hoop. It's within the engeron. Now, because the district court held that criminal immunity does not exist, it did not address whether the 5 types of conduct fall within the outer perimeter. They say in assessing whether immunity does apply, courts must look at the nature of the act itself. Under these standards, all 5 types of conducts that we talked about are official act. They're all President Trump's efforts and duties. They all are advocating for the integrity of a federal election. They say first, Trump's public statements and his tweets are clearly within the outer perimeter of his presidential duty. These are matters of presidential concern. This is especially apparent in Trump's tweets, saying that he's got evidence about this stuff and his public statements are official statements. Second, President Trump's communications with the DOJ, he was acting as a president. Those are literal presidential acts. The Constitution says the president shall take care that the laws be faithfully executed. And deliberating about whether to put a cabinet level officer at a certain position is a presidential duty, not even arguable. Third, communicating with state officials. Trump made phone calls to guys like Brad Raffensperger. The president's take care duty, as we have seen, also includes rights and duties that are growing out of the Constitution itself. These are the implied powers. We talked about the first ring, which is explicit powers. The outer ring would be the implicit powers. And then you have kind of, maybe a gray area that's implied from stuff that's not, you haven't, discussed yet. Because situations change. Hindsight's 2020, right? We're always giving the president, which, by the way, it's supposed to be like the country's president. This includes taking steps to ensure the integrity of federal elections. And the president was doing that. And fourth, talking with members of Congress, including the vice president, as his capacity as the president of the Senate, is clearly a constitutional duty. Article 2 says he can do that specifically. And fifth, organizing contingent slates of electors is the same thing. They fall under the presidential duties because his duties extend to all rights, duties, and obligations growing out of the Constitution itself. Those are plainly within his duties, and so he is immune. They say the prosecution is also barred under the impeachment clause and due to the principles of double jeopardy. We know what the Constitution says about this, and they make a concession. They say their reading is to be avoided. This judge, who's better, is persuasive. When he was writing about this, he said that the English House of Lords could pronounce a full and complete sentence and an acquittal would further bar prosecution. Okay, so even the English get it. Shout out to our friends in the UK. Now, the district court pointed to a 1973 OLC memorandum, and they say a different interpretation. It rests on the assumption that framers and ratifiers relied on formulations of double jeopardy that restricted it to cases where the defendant's life was at stake. Okay, so double jeopardy doesn't apply to all crimes, only like death penalty cases, which would be insane. But if that's what founders believed, there would be no reason to say a convicted officer could be prosecuted. Double jeopardy would be out of the picture. It also assumes the founders departed from the British model explicitly in one way, but implicitly in another way, and that's unlikely too. And so the framers discussed impeachment. The punishment which may be the consequence of conviction upon impeachment is not to terminate the chastisement of the offender after having been sentenced to a perpetual ostracism from the esteem and confidence, and honors and emoluments of the country, he will still be liable to prosecution in the ordinary course after. Okay, so political first, then elsewhere. Then there's another one, James Wilson. He made another statement to the same. You got to go political first and then elsewhere. Now, Madison underscores this. He cautioned against newfangled and artificial treasons, which have been the great engines by which violent factions, the natural offspring of free governments, have usually wreaked their alternate malignity on each other. Okay, by allowing people to say, he's an insurrectionist, just artificial treason, okay? Just insert the word insurrection. Madison got it too. They were pretty intelligent. They knew where all this was going. And the Democrats who don't read history are just like, well, he's an insurrectionist though. So artificial insurrections is a nice tool of tyrants. By requiring widespread political consensus within the U.S. Senate, the historical cooling saucer of the Republic, before a president can be criminally prosecuted, protects the presidents from newfangled and artificial treasons. And contrary to Judge Chutkan, the Supreme Court has repeatedly affirmed that impeachment is political, and so is the principle and constitutionally prescribed method to address presidential malfeasance. And so Trump's defense continuing says, the impeachment judgment clause thus protects presidents from harassing criminal prosecutions by prosecutors and requires Congress to first make a political judgment that the president should be convicted. If, as here, the Senate acquits the president, the Senate has necessarily concluded that the president should remain in office and is not disqualified from service. For a prosecutor like Tishy or Fanny or Jack or Molly or Tom or Jay Brett to conclude otherwise undermines that conclusion. Indeed, a successful prosecution voids it and arrogates itself to a judgment the Constitution reserves to Congress. And so, thus, President Trump's acquittal by the Senate bars prosecution for the conduct that's been alleged in this indictment. Chutkan misses the whole point. The preclusive effect here is from the impeachment judgment clause, which incorporates double jeopardy, but double jeopardy tests wholesale. Saying further, the acquittal reinforces Trump's immunity argument, whereas here, the question is the amenability of the president to prosecution for an official act. The politics and political concerns are at their apex. Before any single prosecutor can ask a court to sit in judgment of the president's conduct, Congress must have approved of it by impeaching and convicting the president. And that did not happen here. And so President Trump has absolute immunity. Saying Judge Chutkan's order should be reversed and the case should be remanded back to Judge Chutkan's courtrooms with the instructions to dismiss the indictment with prejudice. In the alternative, the court should uphold criminal immunity and remand to the district court to apply the doctrine in the first instance. If this court affirms the district court in any respect, the court, Trump respectfully requests you stay the mandate, including possible en banc proceedings or review to the Supreme Court. Signed by John Lauro. So if we don't win here, we're going up to SCOTUS. John Sauer also signing off on this, the team on behalf of Trump doing the appellate work. And you can see this one is in the DC Circuit Court of Appeals. And it's a nice one. And we like to see that materializing and working its way through the courts. I think they are great arguments. I think it's just logical how it works. And for them to upend that is very problematic for the future of the country. Hopefully the courts agree. This is Joe Biden, who got asked about presidential immunity, and he doesn't have much to say because he doesn't have much mental capacity left. But this is what he was saying when he was asked, should any president be immune from criminal prosecution? Which is a very open-ended question. It's, okay, what do you mean? So like no immunity at all? Here's what Joe says. I don't know if he's actually responding to this question or if he just can't think of anything. This is Joe.
When a president, any president, is absolutely immune from criminal prosecution. Any president at all.
I can't think of one.
When a president.
Okay, I can't think of one. So I don't know what he's answering. Should any president be immune from criminal prosecution? Well, not Trump, I guess. You can't think of Barack Obama for drone striking American citizens? Should he have immunity from that? Should we just have total indictment for all past presidents? Okay. So, all right, that's Joe Biden. So not much from him. Now, this guy is saying that Trump's argument for absolute immunity, which is never an argument that he's made. We have read every single stinking motion here, happily, and never once have we ever seen Trump say, I deserve absolute immunity for everything that I've ever done or thought or said. No, that's what they were giving to Hunter, not Trump. That's what they were working out for him, that everything from those years was blanket immunity. So now we're hearing from this guy who's saying that Trump is making that argument and the Supreme Court is going to reject that argument, which, by the way, I agree. It's like, man, you can set up these straw men all day. Is that all you need to do to go on ABC? Just make up something that no one's arguing and then disagree with that? I totally think the Supreme Court's going to deny that. Yes, I also agree. I think the Supreme Court is not going to repeal the 13th Amendment. Yeah, wow, brilliant legal analysis. I told you, the Supreme Court didn't repeal the 13th Amendment. You're like, oh, congratulations. Obviously that was never going to happen.
Overnight, President Trump's legal team filed a brief with the appellate court here in Washington saying the election interference case should be thrown out, again, because of the immunity. Was that expected, and is that part of what you were talking about a few moments ago?
Look, they're searching for every opportunity to delay, to make broad, sweeping claims, to prevent these trials, as Sarah was saying, and she has a good point on all four trials, prevent them from happening before the election. And I think any sweeping argument made to any court, interim, appellate, Supreme Court, on the part of Donald Trump has to be expected. The sweeping claims of absolute immunity, I think, will ultimately, even with this Supreme Court, not hold, but it's going to take a while to get there. That's the problem.
So you were night.
Oh my gosh. He's never, ever claimed that he needs absolute immunity, even with this Supreme Court. What kind of a ridiculous thing is that? Trump has never made that argument one time. Of course. Yeah, because it's an insane argument. They're just saying if it's within the outer perimeter, it's fair game unless he has been impeached and convicted. Obviously, he has not. So we got some interesting people over there who are just making up arguments and having conversations with themselves. But this guy's a little bit more intelligent. His name is James Trusty, and you're familiar with him as Trump's former lawyer. And we're going to listen to him explain a little bit about what he thinks about SCOTUS and these appeals, having worked for Trump.
The United States prosecution for alleged crimes he committed in the federal classified documents case. So just to get your thoughts on this, now that the Supreme Court has refused to fast track the arguments, could this give Trump's legal team a leg up, and how so?
Well, I don't know if it gives a leg up substantively. We don't know how they're going to rule in terms of the immunity itself, but it certainly jeopardizes the March trial date. And I think that's really the story here. You had a prosecutor in a very unprecedented position saying we have to have a speedy trial. A speedy trial right is a defendant's right. It's very unheard of for a federal prosecutor in any district, and I was a federal prosecutor for 27 years, to announce that they've got this specific speedy trial interest where it has to be tried by date X. That was weird territory. It did not pass the sniff test when it came to the basis for an expedition for the Supreme Court, and I think they made the right ruling.
So the question of immunity, as you note, is the larger issue, not the schedule. It's going to probably end up at the U.S. Supreme Court regardless. Do you have any idea of what they might do when they review the case?
No, I mean, look, a lot of lawyers would go poor betting on that.
What's your guess? What's your guess?
Well, my guess is that the first stop is that the Court of Appeals will probably say there's no immunity at all. I'm not particularly struck by the double jeopardy argument. That one seems like it's a little bit of a stretch to say that the legal impact of an impeachment process has any real carry on.
That's Trump's argument that it's legal.
It's kind of it looks like a secondary argument, but I think the primary argument's interesting because you could see the Supreme Court getting to it and deciding to have a bit of a carve-out approach, that if the activity of the president at the time was really connected to core functions, maybe that's immunized. You wouldn't want to have it where a president could have a drunk driving incident or could go beat up Jake Tapper for no real reason.
Well, hang on a minute on that second one. Okay, only kidding. But that's not what anybody's making. No one is making that argument, James. Okay, everybody would say that getting a DUI or backhanding Jake Tapper would be not within the official duties. Probably for Jake. But the point, that is obviously criminal. He could be indicted for all of those things instantly. You don't have to go through all of this additional procedure for something that is obviously outside of the bounds.
And say that they're immunized. So there could be a little division of whether it's something that's really in the wheelhouse of being the president versus being a frolic and detour, as they call it legally. But I have no idea. I think, it's new territory. We have no way of really knowing whether this is going to be something that splits on philosophical lines or not. And we'll have to wait and see for a while, it looks like.
Of course, we also have to wait to see if the U.S. Supreme Court is going to take any action when it comes to Donald Trump's anticipated appeal of the ruling by the Colorado Supreme Court. The Colorado Supreme Court earlier this week ruled that Donald Trump cannot appear on their ballots because they judged him to have participated in insurrection, and according to the 14th Amendment of the U.S. Constitution, is therefore ineligible. Do you think that Trump's legal team will, well, first of all, I assume you think they're going to appeal it.
Sure.
And how do you think they're going to approach that appeal, and do you think they'll be successful?
Well, it's a petition for certiorari for the Supreme Court, and the percentages in general are pretty low about the Supreme Court taking these cases. I think they'll take it. I think this is an outcome.
Because it's a Supreme Court decision.
For a variety of reasons. You've
It's
got
election.
a state Supreme
They're
Court
throwing 'em off
ruling
the
on something
ballot.
that could be viewed as a strictly federal question. You've got all these issues about interpreting Article 3 of the 14th Amendment, whether it even applies to the president. And the district court, although they were no friend of President Trump, they said that's a problem here.
Right, they said he committed an insurrection, but he's not covered by the 14th Amendment.
Right,
Yeah.
right. It's not the sexiest kind of legal reasoning, perhaps, but there's something to it. And that's, I think it was Ty Cobb, who's no big friend of President Trump at this point, was announcing this is a 9-0 winner when it goes to the Supreme Court. So there's kind of foundational or procedural issues that they could hang their hat on, and that's probably safer territory for getting like an 8-1, 9-0 opinion out of the Supreme Court if they rule on more of a procedural or foundational basis. But I got to tell you, in terms of the merits of this thing, the expedited trial that he had included basically embracing the bulk of the J6 committee as substantive evidence of
All
insurrection. I
hearsay.
think that's a horrible precedent.
Yeah.
And then they also relied heavily on a sociology professor who is essentially saying that he is the Trump dog whistle whisperer.
Yeah.
That although Trump said things like go peaceful and patriotically, it really meant unpatriotically and violently. And the thought that any court is deciding something this fundamentally important with that kind of psychobabble is really an extraordinary moment.
So who, in
With
your
no
view,
jury.
is the right one to judge whether or not Donald Trump did participate in an insurrection?
Well, there's a real easy out here,
people.
which is if he is convicted, that could be the obvious basis.
No.
But Jack Smith's
for-
not trying him for
I understand.
inciting
Well,
an insurrection.
he's
Right.
trying an insurrection case,
Good-
but
good
not
point,
calling it
Jake.
insurrection. In
Good
fact,
point,
the most
Jake.
recent pleading, it's like we're going to put everything we can about President Trump disliking, electoral results. But at the end of the day, that seems to be a more solid ground, and that could be where the Supreme Court goes as one of these foundational issues. That we're not going to have mini trials on insurrection. You're either convicted of it or you're not. And that would be obviously a huge win for the president if they go that way.
All right.
Be interesting to see. So they say Trump is
The
an
rare-
insurrectionist. Jack Smith gets convictions on all of the charges, but not insurrection. Then Trump escapes the insurrectionary conviction under SCOTUS, and he escapes criminal liability. Now, I don't agree with James Trusty's take on the double jeopardy portion of this. I think that is cut and dry logic. You get somebody, you impeach them first to make sure it is not political. Then when you're sure that it's not political, because 2/3 of the Senate votes to convict, at that point, it's fair game. You got to have that safety valve. And so I don't know why that is not landing with some people on that analysis, but we'll be here, my friends, to continue to cover this. Of course, we're going to see a reply from Jack Smith. Then Trump will we'll have a response from Jack Smith, and then Trump will issue his reply, and we'll have a lot more filings to attend to out of the DC Circuit Court of Appeals. And so wherever it is you're watching this, my friends, thanks for subscribing. We're covering all of the Trump cases. It is going to be a lot. I was looking at the calendar. We've got a lot of deadlines coming up here, a lot of response deadlines. Trump's got Florida deadlines, Fannie, RICO deadlines. And so we'll be here covering it. Thanks for sharing the channel with a friend or family member. Thanks for sharing a short form or a segment with somebody. Say, hey, did you know what they're doing to Trump here? Look at this. Here's what the motion says. And we'll appreciate seeing you and them here on the next one. All right, my friends. Now, let's turn our attention to what is happening over in Maine, because they are trying to remove him there as well. Ballot removal efforts continue in Maine. We've got litigators there who are now saying they don't even really need to litigate this issue. They can just pick up the Colorado opinion give it to their Secretary of State and say, see, they did it, and we don't really need to have a full trial on this. We just can take a look at their opinion. Even though it's not binding to us, it's already been decided. We don't want to waste court resources. We don't want to have to go through a whole insurrection trial again. So Secretary of State, just take this Colorado opinion, apply it to Maine, and throw Trump off the ballot there. We're going to go through the opinion. Then we're going to hear from Gavin Newsom, who for some reason gives a better answer than many Republicans who are running for president right now, saying that removing Trump from the ballot was obviously wrong. Now, I don't think that he, has a moral stance on this. I think he's just a political maneuverer. And then we'll hear from Lindsey Graham, who gets asked the question, did Trump win? But starting out, this is what it looks like in Maine. The state of Maine, Department of the Secretary of State. And if you're having flashbacks to 2020 here, we were at about this same time in the election season. It was back in 2019, December, when we were watching all of this litigation flying around, and a lot of it was going to the secretaries of states. Okay, we get courts and the secretaries of state collude with one another to change signature requirements, to approve ballot boxes, to extend collection deadlines. The list goes on and on. So the same type of backroom dealing is happening here as well. You see here, this is an update. These are from the challengers. Their names are Kimberly Rosen, Ethan Strimling, Thomas Saviello, and they are submitting a supplemental brief to the secretary saying Trump's got to go. They say, pursuant to the secretary's prior order, in Maine, there was a December 20th order, and apparently that order was ordering these challengers to submit a brief, and they wanted in this brief them to address the Colorado Supreme Court decision. So the Secretary of State sitting there, she's scrolling on her phone like everyone, and then the Colorado opinion comes out. She goes, yippity-doo-dah-day, Trump is gone. What should we do? And so she says, okay, I need a new order on from you who are already in litigation here. Please give me an update on what you think this case means. And they say, happy to. So they say, all right, we're responding to this Colorado decision. They say there, the court held that former President Trump is disqualified from holding office of the presidency under Section 3 of the 14th Amendment, the Insurrection Clause, and therefore he's ineligible to appear in Colorado. Now, we're in Maine right now. But they say here, first, man, this is easy. The secretary should follow the well-reasoned opinion as the best modern persuasive authority on all pertinent legal issues. Now, persuasive authority. Now, this is a technical term of art. This is in the law, it's versus. The other word you'll see is binding. Okay, so think about, the states are separate and they are at the same power level. And so Colorado can do something, Maine can do something, but Colorado's opinion is not binding on Maine. It's persuasive though. And that would be different than if the Supreme Court came out and said something, because we're all under the Supreme Court. All of the states are. So it would be binding if it came from the Supreme Court. That's the difference. Now, and second, she should hold the secretary as a matter of law. Okay, so that this is not just persuasive, because you can reject persuasive argument. As a matter of law, though, now this is a matter of law. You have less discretion about this. The doctrine of collateral estoppel requires her, the secretary, to follow the Colorado court's factual determinations on all essential issues. Okay, Trump doesn't get to relitigate any of this, and accordingly remove Trump from the primary ballot. We talked about the dominoes, man, and all it takes is one, and then they're all going to say, see? So here is what these petitioners say. As noted in Anderson, the Colorado trial court permitted multiple intervenors to participate. So a lot of people got to come in and play. They allowed sufficient time for extensive pre-hearing motions, which all parties vigorously engaged in. And we covered Colorado. Okay, all of these I would disagree with, but we'll just read them. Issued 3 substantive rulings on these motions, all in advance of the trial, saying the trial, the insurrection trial to remove the number one candidate from the ballot, lasted 5 days. There were opening and closing statements. There were direct and cross-examinations of 15 witnesses, including Stinky Eric Swalwell, and there was a presentation of 96 exhibits. Wow. And so they're trying to bolster their case like this is legitimate, right? They're trying to show you this was a legitimate trial. We really did a lot of work here, 96 exhibits. The documentary evidence was overwhelmingly evidence in the public domain, which the parties and indeed the entire country had known for over 2 years. And photos and videos were submitted of Trump's speech and of the subsequent attack on the Capitol. And Trump's tweets were there, Trump's statements were there, his rallies, his news conference were there, and they submitted the January 6th report itself, which is completely illegitimate. The whole report is illegitimate. It was not an adversarial proceeding. There was no cross-examination. There was no minority party presentation of any witnesses. There was no alternative theory at all. It was a giant book report. And it was not even interesting. It's like a, probably D-. Just try harder next time, Liz. Stop copying your homework. Moreover, the legal and factual complexity of this case, they say, did not prevent the district court from issuing a very comprehensive 102-page order, which she found kept Trump on the ballot. Hello, did you forget that part? And nothing about the district court's process suggests that President Trump was deprived of notice or opportunity to fully respond to the claim or to mount a vigorous defense. Okay, so Trump knew this existed, and as part of collateral estoppel, one of the things is like the party, you don't want a situation where you've got to re-litigate against a party in all 50 states. It's like, okay, we already beat him here. We got to beat him here too? Okay, we're going to beat him here too. Okay. So what if they just show up on one case and they give everything they've got in the one case? And it's like exactly the same carbon copy case across the country. You just say, all right, look, they should be a stop from re-litigating. We've already done this. We've already, it's the same thing. And so they say that is, if that party had the full opportunity to respond, there's very elements. Is this collateral estoppel? Does it apply? We'll see if they get there. But they're saying essentially Trump had a note. He had notice. He could have shown up and he put his best foot forward and the Supreme Court found that he lost. Now here they say where the facts, evidence, and legal arguments are almost or in fact identical to the extensive Colorado record, the secretary should just follow the holdings from Colorado. Just do whatever they said on all pertinent legal issues, saying Maine courts often rely on persuasive authority, by the way, from the highest courts in other cases when it's new in our place. The law court regularly cites her sister court in Colorado, including for interpretations of the Constitution, and they give us some examples. See, you've done this before. Now, these holdings from Anderson in Colorado that Maine should follow here include, this is what you should include. 1, the Constitution empowers states to limit access based on qualifications, and Trump is an insurrectionist, therefore he's not qualified. Congress does not need to enact enabling legislation to permit this enforcement. So you can find an insurrection without an actual finding of an insurrection. Okay, so Congress doesn't need any legislation. Okay. So, of course, why would you need due process or anything like that? Now, the political question doctrine does not render this case non-justiciable, so they've got standing. Section 3 applies to President Trump because he did serve as an officer of the United States. That's what the Supreme Court said, not Judge Wallace at the district court in Colorado. But the definition of insurrection is very broad. It includes the concerted and public use of force or threat of force by a group of people to hinder or prevent the government from taking action. And 6, engaged in, also is very simple, an overt voluntary act done for the purpose of advancing an unlawful purpose. And then 7, Trump issued a speech inciting the insurrection on January 6th, and he was not protected by the First Amendment. All of that, they say, just adopt. Specifically, they say the U.S. Constitution authorizes states to assess the constitutional qualification of presidential candidates. And states may exercise their power to decide who shows up on their ballots. Maine has also exercised this power, enacting provisions that allow voters to challenge the qualifications. However, here, whereas Colorado empowers state courts to adjudicate these things, Maine entrusts the Secretary of State. Okay, so courts do it in Colorado, but only the Secretary of State makes these decisions based on the facts and the law, which is why this one's interesting. Don't even really need a trial or a court. Just ask the Secretary of State to do it. Let's see where this goes. Now, furthermore, because there is no textually demonstrable commitment to Congress to assess this, the Colorado Supreme Court held this is not even is not a non-justiciable political question, so you can take action. saying the Colorado Supreme Court also rejected Trump's primary evidentiary objection, which was raised in these cases, and those are inadmissible. He said that the January 6th report was hearsay, and that's just the beginning of the problem. Not only was the testimony hearsay, out-of-court statements made to prove the truth of the matter asserted, you can't cross-examine the January 6th report, right? Like, it comes in as just a book report. You just submit it. Can I ask questions about where this? No. Can I challenge this? No. So obviously, as a piece of evidence in this trial, it's clearly hearsay, and it wasn't even, appropriate. But neither was the trial in the first place. But the generation of that report was also created by an illegally constituted committee that had no minority representation other than Cheney and Kinzinger. They should have had five, they had 2. There was no minority report. There was no cross-examination of witnesses. There was no oppositional adversarial statement, opening statement, closing statements, no presentation of evidence from Trump's people at all. So it was all just a sham. And then they put it in a book report, put a bow on it, and gave it to the judge. And she just said, that's great evidence. So in rejecting the bias argument, they say the court not only credited the cross-examined testimony and evidence that the J6 report was not compromised by bias. I don't know how they can even say that. But emphasized that Trump generalized complaints about the political backdrop would be contrary to the plain text of the law. Now, the dissents in the Anderson case should not affect the outcome here. And they say, finally, in the majority in Colorado, all of them refute the other judges' assertions that the 14th Amendment cannot be enforced through a state law cause of action, and that judge is wrong about whether this case can move forward. Now, here is the collateral estoppel part. Okay, Trump's arguments have already been exhausted. They say even if the secretary is not convinced by this evidence that's already out there, so the secretary you can just decide on your own, because we already submitted it to you. But you should also know there's this concept called collateral estoppel. It's also called issue preclusion. It prevents the relitigating of factual issues that have already been decided, saying it can be applied wherever we want. We got full faith and credit under the U.S. Constitution, and the Constitution literally requires the Secretary of State in Maine to apply the doctrine of collateral estoppel to the judgments of other state courts. They've already litigated, full faith and credit. You can just transfer it. It's fungible. For the purposes of collateral estoppel, a judgment is considered final and notwithstanding the pendency of any appeal. Saying Maine permits the offensive use of non-mutual collateral estoppel, meaning they're the ones who are initiating it, like Trump is not bringing the case there. Whereas here, a plaintiff, or in this case, the challenger, who is not a party to the original proceeding, seeks to apply the doctrine to estop a defendant. Like, these are not even the same litigators, right? The people who are in Colorado were Coloradans, not Maine people. So they say here, you can still use this on a case-by-case basis if it's the similar issues of judgment that we're discussing. And so the analysis here really determined that it turns on whether Trump had a full and fair opportunity to defend himself. And they say Trump did. In fact, he showed up, and they say Trump made these arguments and we had these findings. But here, Secretary of State in Maine, the interest of justice weigh heavily towards applying collateral estoppel to resolve these shared factual issues. This holds especially true given that the Colorado case was litigated in a 5-day trial. You don't even have trials here, Secretary of State. So it's the same counsel, and Trump's arguments were there, and they focused on questions of law, not on material fact. And so for these reasons, in Maine, the Secretary, without any other trial or without any other process, should just simply refuse to list Donald Trump on the presidential primary ballot and on his because he's constitutionally ineligible to serve. Signed by Benjamin Gaines, a Maine lawyer in Brunswick, along with James T. Kilbreth, another Maine lawyer in Portland, Maine. Counsel for the challengers all submitting this because they're basically cheaters, right? I mean, that's really what this comes down to. If you can't beat your opponent, you got to get him taken off the board. And they've been trying this for months now and years, really, to sideline him. They don't want to run against him. They don't want the people to be able to go vote for him. They want to take him off the ballot. Now, some lefties are faking like they have some concern about the future of America. Here's what Gavin Newsom says. He's actually defending Donald Trump. Thanks to Colin Rugg, at Colin Rugg on the X platform, for amazing work. And now he got this clip from Gavin Newsom, who was responding to Trump's removal.
Governor, what do you think is going to be the takeaway after this debate from the American people?
I think it will be clear that Trump comes out the dominant force after this debate. I mean, this is the XFL. This is JV. I mean, and honestly, I mean, this is maybe a vice presidential debate. These guys are getting lapped by Donald Trump. It's not even close. It's not even interesting. And I think what's most interesting to me is, do they recognize that? Or are they actually going to show up and run against the guy that's in the way of their prospects to be the nominee? It's a zero-sum game. It's a binary choice at the end of the day. It's not a ranked choice voting. So either these guys come after the front runner and distinguish themselves, or otherwise they're wasting everybody's time. And I say this with love and respect. There's a reason some of the advertising is being discounted for this debate. People don't even want to tune in because they know that fundamentally.
All right, so interesting. This is what Newsom had to say on the Republican primary. So the actual comment from Newsom came after Lieutenant Governor Elena Kounakoulis. Newsom apparently said this, according to Colin. Says there is no doubt that Donald Trump is a threat to our liberties and even our democracy. But in California, we defeat candidates at the polls. Everything else is a political distraction, he said, as he talked about the idea of removing Trump from the ballot. And I don't know if this is a good cop, bad cop routine. You know, Governor Newsom says, no, we got to keep Trump on it, while Lieutenant Governor Elena Kounakoulis, she's the one who's actually removing him or trying to remove him. And so the battle continues. Lindsey Graham was asked about this. He showed up on some mainstream show, and this is what this sounded like. He was asked, you know, Trump keeps saying that he won, and that's really offensive. You know, I teach my kids better than that. What say you, Lindsey?
I have to ask you, the president, former President Trump, continues to say he won the election. He claims to be an election denier proudly. Now, we teach our children, when they lose something, to shake the opponent's hand and move on. Are you concerned that the president former president is not setting the proper standard going forward here, sir?
Well, you know, Hillary Clinton had the same view that she was cheated. He's not the first politician to claim to have been denied a fair election. But here's what I would say. I accept the election results of 2020. I'm worried about 2024. If President Trump puts a vision out improving security and prosperity for Americans, he will win. If he looks back, I think he will lose. So at the end of the day, the 2020 election's over. For me, we need to secure the ballot in the 2024 cycle, but Donald Trump's not the first person to complain about an election.
But
That's absolutely true. We've got clips of Democrats doing it for 20-something minutes. Now, they're not getting indicted by their political opponents. Not yet. One can only hope. We'll see what happens in the next election. So you see, Maine is once again going to the Secretary of States. The Secretary of States have a lot of power to conduct the elections. And now they're trying to get Trump removed without even a trial. Colorado did it. They got what they needed. I don't know who got what done at that Supreme Court there, but man, they got the votes and Trump started the domino there, and it's going to other states. And so we're going to be here continuing to cover this and all of these attempts and more. So thank you for subscribing to our channel, my friends. Thanks also for checking out robertgovea.com. That's our website. My name in there, a little hard to spell, but robertgovea.com. And what you'll find there is all of these PDFs are uploaded on our reports section. We've also got the shop, which is now available, so you can grab some new gear. Great way to support the show. Learn about the watcher symbol. And we put a lot of effort and thought into this, so check that out. robertgovea.com/shop. Thanks for supporting us, and we'll look forward to seeing you back here on the next one. All right, my friends. Now, we got one final segment on the day, and this one has the H word in it. So just be prepared, little ones at home. HE double hockey sticks is coming up. So earmuffs if you need them. But this is what is happening. Donald Trump posted some very interesting truths saying that Jack Smith and all those deranged prosecutors, they can enjoy their Christmas straight in hell. We're going to go through what he posted and then here's some reaction to this, because Lisa Monaco, who's really in charge of the DOJ, really, is saying there's an unprecedented rise in threats against the DOJ. FBI is investigating threats against the Colorado Supreme Court judges, and Trump is exercising maximum wingspan of his free speech. Remember that there is this gag order that we're battling over in Judge Chutkan's courtroom. She says she still has authority to exercise discretion over the operation of the case in her courtroom, even though it's on appeal and all the deadlines are stayed. But Trump is commenting specifically about Jack Smith. And I want to share this, and I just want to preface this by saying I think that Trump is speaking non-violently here. Okay, I always think that. Now, it's a fairly difficult thing because I see something, having watched a lot of Trump, and I understand what I think to be his demeanor and his character. But when I read something that's very different than what somebody like Jen Psaki reads, okay? Jen Psaki reads something, and she has flashbacks to World War II. She thinks we're in the middle of an Adolf insurrection. She thinks that people are going to be eradicated from the civil service. I don't know if she really thinks that or if they've just got a role to play. But my point is, okay, language from Trump gets spliced and diced, and this one I think is going to be very curious. Like, I can expect to see this in a court filing any minute now. And they're going to say that this is Trump getting over the line, right? But I do not think so. I'm not interpreting it that way, and I will share that with you accordingly. But this is what Trump posted. This was on Truth. He said, Biden's flunky, deranged Jack Smith, which he's allowed to say now, he can call out Jack Smith by name, should go to hell. See that? And that word should, I think Judge Chutkan is having an aneurysm over that one right now. Now, of course, the interpretation of that would be after the natural expiration of a person's life, after somebody, meets their maker, whenever that's going to happen to be. There are opinions about where someone should go. Okay, we say that all the time. Where they should go, and I personally don't try not to even think, in these terms. Like as Trump's criminal defense attorney, this type of statements give me a little bit of a panic attack. But as somebody who thinks that Trump should be able to exercise maximum free speech, I think that what he's doing here is very interesting. Okay, it's very provocative, certainly, but it's etching in a line, and it's going to be curious to see what the DOJ does with it. But here's my point. Certainly, Trump's statement, that phrase, that word should, is I think a lot of effort, a lot of attention will be paid to that single word. It could be can go to hell, will go to hell. There's a lot of different words you can put in there, but should implies maybe missing a temporal element to it that they are going to freak out about. I can just envision it. So anyways, the rest of his statement says, he is helping his corrupt and incompetent president to destroy America through weaponization and election interference. Smith is a crooked prosecutor who shouldn't even be allowed to be in the position he's in. It's prosecutorial misconduct. And he's talking about a ruling here, a motion that we've already talked about from Ed Meese from the Ronald Reagan era, has him figured perfectly. And we read through that full amicus brief. Ed Meese was saying that Jack Smith is illegitimate, right? He was appointed by Merrick Garland, but not by the president and not confirmed by the Senate. So it's an invalid appointment under the special counsel statutes. So that was the first incidence of the hell word from Trump. And he also posted some other things on the line. He said, softball question from ABC Fake News to Attorney General Garland's boss, Lisa Monaco, who we're going to read about in a minute, asked the question to Lisa, Lisa, has the President Biden ever raised the classified documents investigation, the probe of Hunter with you or the AG, or tried to influence you? Has he ever done that with regard to President Trump? Lisa Monaco's fake answer, says Trump, is no, and the Attorney General has been exceptionally clear on this point. Yeah, right. What a complete lie, says Trump. He speaks to them all the time, and she speaks to deranged Jack Smith and others. She also speaks to the scum outside her office, like Andrew Weissman, essentially her boss, who has desperately fought for years to, quote, get Trump. Or the new attorney brought in to help derange Jack Smith. It's all about election interference. And Biden was pushing Garland and Monaco to act, and fast. They think the American public and even the Supreme Court in the United States are stupid. No. Crooked Joe Biden has never spoken to Garland or Monaco about Hunter or Trump. That one gets lie of the year from Trump. Another one from him is this one. Says, it is hard to have a truly great Christmas when you have a crooked and incompetent president who wants to put his political opponent in jail and who has been working hard for a change, illegally using all of the levers of law enforcement to do so. We are in the fight of our lives to save our country from madness and doom. MAGA 2024. And then lastly, this one is from Trump. He says, 2024 will go down as the year of a great and fully coordinated illegal election interference by crooked Joe Biden, the worst and most corrupt president in history of the United States. The DOJ, FBI, AGs, DAs, all throughout the country. But despite it all, in the end, there will be a big and glorious victory for those brave and valiant patriots who want to make America great again. Merry Christmas to all. And so there was one other post from Trump where he said, I hope they all enjoy, Christmas in hell or something like that, which apparently I did not clip. I thought I got that one. But that's the point. Okay, so Trump makes statements like this. I think it's much ado about nothing, but you see where this is going. All right, and this is what we've been talking about here for a long time. As the election gets closer, they're going to say to us, Trump is going to insurrect us again. That there's going to be a 2.0 of this. Okay, they're already laying the framework for this. And so here is the next step. When we throw him off the ballot, guess what? The judges in Colorado, they're getting attacked now. So the FBI needs to investigate. And who are they going to investigate? Oh, the critics of the people who are removing Trump from the ballot. What happens next? Lisa Monaco says there's going to be an unprecedented rise in threats against the DOJ, and they're going to tie it directly back to statements like that. Okay, like Trump is saying that Jack Smith should go to hell tomorrow, which is not what I'm reading it to be. But you can see how Jen Psaki is going to take that. It's probably going to be on the screen on CNN, the rest of the week. So Lisa Monaco was investigating threats against the DOJ. And for some reason, I don't have that link either. Let's get it right now. From Lisa Monaco, tells us that the Deputy Attorney General, she said on Sunday that the government weaponization, claims of government weaponization, which is kind of like this whole channel, have contributed to an unprecedented rise in threats against public officials, which I have always condemned here, always. I want all people to have nice, long, fruitful lives. And I hope our misguided public officials and the deranged thugs like Jack Smith, I hope they wake up. They could be useful to America. If they wake up and they go, what am I doing here with my life? Why am I doing this to America? I have to live in this country. I hope they wake up and realize and come to the table. But my point is, this is already illegal, okay? It is never a good idea to even really message public officials, unless you absolutely have to for legal services or for services, right? Anytime that Joe Biden says, send me a text, America, bad idea. Okay, these are all traps. Anything that's even interpreted as a threat is gonna be deemed a threat, and the person sending that will end up on a list. And it's already illegal to do that, and like very illegal. Like threatening your friend or your coworker is very different than threatening a public official. They make the rules to protect themselves aggressively. So here's what they say. Monaco shows up on ABC News. She pushed back strongly on Republican claims of a DOJ that's been weaponized. She says those claims bear no resemblance to the Justice Department that I know. We're all just doing justice together. It happens to be against a political opponent that we all detest, but it is still justice. She says, the Justice Department that I know, and that's a really bad statement. Like, you just say, I don't know it. Well, okay, well, are you like reading the news? She says it's filled with dedicated men and women, investigators, lawyers, prosecutors, analysts, professional staff who get up every day. They get up without regard to who's in the White House or who's in Congress. Of course, they don't care. They don't care who's in charge. Their job is to go push for the Democrat Party regardless of who's in Congress or who's in the White House, and they do it. When Biden's in charge, they just cover up for Hunter. When Trump's in charge, they make up fake indictments. When they're bored, they just go indict people for fake kidnapping crimes. When they really want to make sure they can hit their political enemies, they fail to secure the Capitol building, the most secure building in the whole world, when all the Congress people should be there. It's all rigged. Anyways, Monaco said, these claims really bother her, and they contribute to the toxicity of the Washington environment. Poor Lisa. As she's indicting her political enemies and the J6ers are rotting away in gulags, says what we've seen is an unprecedented rise in threats to public officials across the board. Already illegal. Law enforcement agents and prosecutors and judges with their areolas and election officials. And we are seeing that and responding to it. I'm sure they are. I'm sure people are getting charged with felonies all over. So it's really hard, okay? Maybe the Justice Department shouldn't be such a politicized tank of garbage, okay? And people wouldn't be upset with you, and it wouldn't be so toxic. Maybe you should separate justice from your political vendettas, and things would tone down a little bit. And I'm not endorsing any of these comments or threats or harassment, right? It is illegal, and I really encourage everybody to not do anything even resembling that. Now, of course, you already know that, but the point is, several members of the Republican Party, notably President Trump and several GOP congressional leaders, have repeatedly claimed, they say without evidence, we've got look, every single video on this channel is one bit of evidence. There is weaponization of the federal government, and that government agency is working to promote Biden's so-called political agenda against Trump. Monaco reiterated. She said that special counsels Jack Smith, who is illegal, and David Weiss and Robert Hur are conducting their respective investigations in an unbiased manner. Right. Yeah. David Weiss worked with Hunter's brother and has been in Delaware for years. And Robert Hur has I don't know, 1/50th of the budget to investigate this. And the whole thing is going to just be buried. Now, Hunter has had his tax crimes also investigated. Whistleblowers came out. We already know that they blew the whistle on that. We know that the DOJ was trying to ensnare basically limitless immunity for Hunter for no reason. So it's a cover-up. So asked if 3 prosecutions are operating without regard to anything but the facts and the law, Monaco said yes. And the reason I say that here is these are matters of utmost importance and significance. Of course they are. Yeah, they're important. One is going after your political opponent, Jack Smith going after Trump. Weiss is covering up for the Biden crime family, and so is Robert Hur. Several GOP members made similar claims of politicization within Colorado. They removed Trump from the ballot last week. And their 7-member bench was entirely appointed by Democrat governors, 6 of whom won retention elections. The 7th will do so next year. So all the Democrats are removing Trump. Former Attorney General Bill Barr touched upon this sentiment last week. He said that Colorado's ruling is going to be counterproductive as Trump is going to feed on the grievances, which, I mean, it's a legitimate grievance, Bill, is it not? Do you think it was appropriate to remove him? So they don't call it a grievance. Feeds on grievances. They keep delivering him blows. And it will use the decision to reinforce the narrative. It's not a narrative that the federal government is working against him. They clearly are. It's documented. There's 4 different indictments, all operated out of the White House. So, all right, that's the Hill. Lisa Monaco's hitting the panic button over there. And, it makes me nervous, my friends, because I think, look, the FBI and Homeland Security and all these people, they had dozens, if not hundreds of informants there on January 6th. They knew that there were going to be a bunch of people there. They knew it was going to be filled with Congress people. And they did not secure the building. And Stephen Son raised some serious alarms. They couldn't secure it. He asked for help. They didn't care, right? The whole situation was orchestrated, in my opinion. And the same thing happened with the Whitmer plot. Okay, we've got innocent people who were prosecuted by our feds and acquitted. Others were not because they took another bite at the apple. But it is being rigged. So even if there is nothing that is going to happen, I don't put it past them to manufacture something to happen and then tie it back to this case and to everybody else who says the government has been weaponized. That's us. That's you. I know many of you. So it's concerning. And when they start talking like this, an unprecedented rise. So what does that mean? What are they going to have an unprecedented response? Maybe they should get the CIA and the FBI to censor us again. Anyways, here's Karl Rove. Now, they're creating some other bad phone call situation. I believe this one's out of Michigan. And so Karl Rove, who everybody has forgotten about, is now showing up on Fox News and trying to remain relevant. He's one of the architects of the failed Iraq invasion, along with Bush, too, who got us into 20 years of war, resulting in $80 billion worth of equipment left over there, along with tens of thousands of Americans dead, all as a result of this. And they're going to tell us that Trump's a bad leader and irrelevant. Here's Karl.
All right, I want to ask you about something else that's popped up, and this is the Detroit News is reporting on a recorded phone conversation between former President Donald Trump, the RNC chairwoman Ronna McDaniel, and two Wayne County Board of Election officials. This was about certifying the results of the 2020 election. They quote Donald Trump as saying, "We've got to fight for our country. We can't let these people take our country away from us." Ronna McDaniel then says, "If you can go home tonight, do not sign it." That's the certification of the election results. "We will get you attorneys," followed by Trump saying, "We will take care of that." Those two officials apparently had already voted to certify the results. They tried to rescind their votes, but weren't able to do so. What do you make of all this?
Yeah, Karl.
I think the former president's got a problem with this. They had voted to certify the election. He attempted to force them to change their decision, which they tried to do. I think this is what we would call election interference. And just as he got into trouble in Georgia over a similar act, calling the Secretary of State and saying, "Find me 11,000 some odd more votes," this is a problem. The former president should not have been doing this. These people are supposedly independent officials who are supposed to certify the election based upon their review of the process and the procedures in place, and he's attempting to get them to change their opinion after the fact. This is not a good move if accurate, and if this tape is true. The former president's created another problem for himself.
All right, so they're very likely going to indict him again. Maybe they'll indict him again. Maybe they'll indict the alternate electors. There's a bunch of other investigations happening. I think Arizona's looking into it and other places. So we'll see if there are more charges that come. Maybe they'll realize that every indictment just increases his energy level, but maybe not. This is Jen Psaki on MSNBC's hit show called Inside Jen Psaki. And here she is with her BFF, Andrew Weissman. Andrew Weissman, of course, is a rabid anti-Trumper, somebody who's worked against him for years now. And they're commenting about what Trump might do when he gets his hands on the DOJ.
No, I mean, you mentioned Attorney General. Typically, as I think most people know, an Attorney General will be nominated, would have to be confirmed by the Senate. But one of the things that Liz Cheney talks about in her book and has talked about since is this possibility or plan that he could nominate people he knows aren't going to be confirmed and then appoint them as acting, which means they can't serve as long. But what would that potentially mean? You have an acting Attorney General who's a political appointee of Trump's. What could they do?
So it's important to remember we don't know what the Senate will look like either. And so there could actually be people like Jeff Clark or Sidney Powell or Rudy Giuliani who are confirmed. But if you have somebody who is there as an acting, one, they're also more beholden to the president, as that's why I think you saw so many acting positions under Donald Trump when he was president. And they can do exactly what a official, not confirmed person can do. There's no difference in terms of their powers, but it does allow essentially a circumvention of the Senate confirmation process for a time period, but you can just keep cycling through these people. Also remember that Donald Trump has talked about getting rid of the civil service, so that the so-called deep state, his view is those people who are adhering to their oaths of office can simply be eradicated.
Eradicated. Oh my gosh, just like Adolf and Mussolini. You know, he's just going to eradicate all of these government bureaucrats, right? With the stroke of a pen like Thanos, you're all gone, which, you know, is gone from the federal government, which would be a nice thing for all of our pocketbooks, because I don't know what the heck they do in there other than perpetuate the bureaucracy. Now, my friends, that's Jen Psaki, Karl Rove, and the language is getting pretty aggressive. I think that there is going to be a lot of efforts to expand this, right? To expand, they want insurrection 2.0. I think it's the only thing they've got left. FBI's investigating threats also to Colorado. You can see Axios reported this, so the FBI is digging into it. FBI and Denver police are investigating threats to the Colorado Supreme Court justices, who last week that Trump is off the ballot. Again, it's all illegal. A Denver Police Department spokesman said that they're providing extra patrols around the justices' residences because there are threats after they removed him and wrecked democracy. Analysis by Nonpartisan Research, the name of the nonprofit is called Advanced Democracy. Oh my gosh. It's like, can you just come up with a name? Like, we know that's a lefty group. Analysis by Nonpartisan Research nonprofit called Advanced Democracy showed significant violent rhetoric from Trump supporters online against the justices. Significant violent rhetoric. What do we call them, morons and idiots? Is that violent rhetoric? Those judges did a terrible job, you know, they're wrecking American democracy, like those types of things. You know, I don't think that's problematic at all. In fact, I think that's free speech, but I don't know what they classify it as. NBC reported about the ruling. There are posts that demand the judge's personal info, all of which I oppose, okay? Any swatting, any of that stuff, I oppose. But they don't oppose it. They don't oppose it. They had people protesting outside Judge Kavanaugh's house and Amy Coney Barrett's house. Now, the FBI is aware of the situation. We're working with local law enforcement. It says we'll vigorously pursue investigations of any threat or use of violence committed by someone who uses extremist views to justify their actions regardless of motivation. Who issued that statement? I want to know who wrote that statement. That's the FBI? What is this extremist view? What does that mean? You're upset that a judge removed a candidate from the ballot? Is that extremist? Okay. The Denver Police Department spokesman confirmed officers were, quote, investigating incidences directed at the Colorado judges and will continue to work with law enforcement to thoroughly investigate any reports of threats or harassment, both already crimes, which is good. They should, right? If you're threatening or harassing someone, yeah, you're going to get investigated for that. That's illegal. But if you're talking online that these judges are demented, that's a different category. Now, police will provide additional safety support if requested. A spokesman from Colorado said via email that it did not comment on security-related matters. So just so you know, like you see where this goes, they do something monstrous and anti-democratic. You complain about that because you have free speech in what used to be an American democracy, and they say you are a violent extremist, and the FBI is pursuing you, maybe, for using extremist ideology to pursue, I guess, your political ends or something. So, all right, my friends, that is about what we expect. I am, unfortunately feeling like we're going to see more of this. Like they're going to ratchet this up. They're going to do something to either cause somebody to snap or they will orchestrate the snap. And then they'll use this to backfill their arguments. And we'll see what the social media companies do. We'll see what stops they pull out. I think 2024 is going to be spicy. I'm hopeful that it's not, but I think it's going to be. And so we'll be here to continue to cover this, my friends. Thanks for joining us as we do. Thanks for checking out robertgovea.com to sign up for our daily newsletter. We've got all of these stories are synthesized and sent to you every single day after the show. So Robert Govea is where you can sign up for that. We've also got our brand new shop where you can grab some new gear. We really appreciate you supporting the show, grabbing a Watching the Watchers hat. We've got Libertas Justia is the watcher on the top, the unbalanced scales of justice. We have the shield so we can identify each other. We've got the sword, which cuts through the bonds of ignorance. And so thanks for supporting us at robertgovea.com/shop. Thanks for subscribing here, and we'll look forward to seeing you on the next one. All right, my friends, that is it for us on the day. We got Trump saying that Jack Smith and the other DOJers can, go someplace. Maine is now trying to remove Donald Trump without any trial or anything, just saying, hey, just pick up the Colorado case and remove Trump here. And we've also got Trump's opening brief slamming the unprecedented prosecution in the DC Court of Appeals. And we'll hear more responses on that in the next coming days from Jack Smith and elsewhere. But now, my friends, let's hear from you. Let's see what you have to say about all of this over at watchingthewatchers.locals.com. We do members-only streams in the morning. We do Saturday streams for our members. We do after parties here. So after we're done here, we're going right over there to hang out and debrief. And so come check it out, watchingthewatchers.locals.com. And starting us off, and YouTube members, speaking of YouTube members, we got 5 new ones from Tony Hay Munkets in the house. What's up, Tony? I hope you had a beautiful Christmas, my friend. Says Ms. J's coming in. Diane B, Drew M, Nerpy is here. We've got Peter R all coming in. And so YouTube friends, we'll see you on our members only stream in the morning and our Saturday stream. But we'd also like to see you on our after party. So on the YouTube community tab on the YouTube channel, scroll over to community, scroll down, grab the Telegram link. That's where we'll see you. And Tony, hey, thanks for the membos, my man. Welcome aboard. Glocky McGlockface says, so according to this map, those so-called second set of electors aren't even illegal in places like Georgia. Yeah, I think a lot of people have alternate slates of electors in case there is a contested election. It just makes sense to have somebody else there to slot in. Good to see you. Voice of the People says Fauci, is set to testify again in congressional oversight hearing in 2 weeks. That's going to be a fun one to stream when it happens. Ooh, Fauci. Okay, so Fauci's going to be back. And he's retired now, right? So he's officially a private citizen. You're right about that, Voice. That will be a fun one. This one came in from Glocky McGlockface over on the locals. Says, hey, Rob, do me a favor and watch this and let me know if they should be arrested by the feds for trying to overthrow an election. Let me see what this one is. Is this one, pulling this one open here. Here's MSNBC reporting on Hillary Clinton. And should these people be arrested? Here is what Kyle Becker pointed out. This is curious. Clinton backers are calling for the overthrow of Trump's election. Clinton backers, they want to overturn this thing. Here.
This is that bit of hope that Hillary Clinton supporters are holding on to. Fact from fiction. What happens here?
What happens here is nothing. This is not going to change the outcome of the election. It is certainly an oddity of our democracy that in almost every race we count the ballots and give the victory to the person who has the most votes, except for the presidency, where often, as we see this year, as we saw in 2000, as we've seen in earlier races, the person with the most votes sometimes does not become president. In this case, by all accounts thus far, some counting still going on, Hillary Clinton. But here's why. If you look at a map across the country, 29 states under state law bind their electors, and 5 of those states have actual criminal penalties for it. So what that really means is those electors, although it is a weird system, are bound by state law to uphold the results of their state, and that is why they have to stay with what happened in the states. The other point I'll make for people who are interested in systemic reform, not changing the outcome of this race, which, as I explained, isn't going to happen. There is a proposal that has moved across the country for future elections to say, what if we switch the states to a national popular vote and set up what's called a trigger? It's an interesting idea that basically says all the states would agree that once they all change their races and they all change the state law, they would all abide by one national popular vote because we're one nation, because this constitutional system.
Amazing. So whoever wins, they all vote in alignment with the national popular vote. That would be insane. Okay, that would be the states giving up their votes to to California and to New York and just giving them total autonomy over that. Good to see you, Glocky. Yeah, I'm not sure. I mean, they were plotting to stop Trump for years, even before he actually came down the elevator. You got Tony Hay Munkets with more membos coming in. Brian B., Michael S., Linda H. We got Welshies coming in. And we got Heard Not Seen is coming in, all courtesy of Tony Hay Munkets, bringing in 5 new membos in the House. Hey, Eddie Oliver's here from the great state of Texas, says, those are a lot of fancy words you read there, Rob. You really think these lefty judges can read that and understand it without the crayons? Probably not. I think Judge Chutkin is having a difficult time over there, which is why she's being explained this a lot of explaining going to her. Now, we'll see what the Court of Appeals does and then ultimately SCOTUS, but no, I don't think that they're very capable. Good to see you, Eddie. Boy Wonder says Bush should have been brought in front of the Hague for war crimes. Need to be careful on immunity when their own immunity could be questioned. Yeah, judges need to be careful on immunity when their own immunity could be questioned. From Boy Wonder Robin. Thank you, Boy Wonder. Good to see you. Yeah, I mean, no consequences for him. No consequences for really anybody. They can just do whatever they want unless you're Trump. Tony Hay, 5 new membos. Tony, man, that's a lot of membos today. And here I think was the list. We got L, HD, DG, we got Mike M, and Tyrannus Cygnus is all in the House courtesy of Tony Hay Munkets. Tony, you're the man. Thanks for bringing in the membos today, my friend. We got 2-tier, says someone said the Supreme Court might not step into the Colorado case because the GOP primary is a private group deciding their leader, and the Supreme Court won't step in to tell the bank how to decide their president. Only the general election is federal. That's interesting. So it's just like they're just not, yeah. I think that they might anticipate where this would go, saying that whoever's not on the primary is also not going to be on the Fed. So hopefully they have enough foresight to address this before it becomes a problem. Because when they address it when it's general election time, the damage is already done. So it's, they can see and think down the line, but yeah, I'm actually with you on this 2-tier. I get nervous about the Supreme Court in general. Like I'm worried that they might just say, like, all you need is 2 judges to say it's just a state's issue. Okay. Like you just need Roberts and let's say Amy Coney Barrett. They say it's a state's issue where we're just going to let the states decide it because we don't want to get involved. And I think there's some authority to that, like the state legislatures are the authority of what governs the election in their states. But then it's the federal election where, the federal supremacy clause comes in and they're playing in the federal system. So then you have some federal oversight, obviously. But I get nervous that they could split that. And, then you just get 2 of those judges plus the 3 lefties and it's a 5-4 decision. And they just defer it, essentially. Like that makes me very nervous. But I'm hopeful that doesn't happen. What's up, Tony? Hey, with more membos. LD, HD, D. Gillis, Mike M, and Tyrannus Cygnus all coming in. Tony saying, another thing you can blame Baby Bush for is Obama being president because he stinks so bad. There's no way a Republican was going to win after him. I know a lot of good people that voted for Obama. And I think a lot of them felt like they got duped pretty badly. Yeah, Bush was a disaster for the Republican Party. And then, arguably we got Trump out of that, which after Obama, we got a Trump. So ebbs and flows. We got R. Alvey. What's up, R. Alvey? Welcome aboard as a new supporter. We got John Butner's coming in. John, welcome aboard, our newest supporter. We're going to see you tomorrow on our members only stream. Hopefully see you in the after party. We got Daniel Layton. What's up, Daniel? Says, Merry Christmas, Rob. Merry Christmas, Daniel. And a Happy New Year. I hope this new year brings you nothing but success. Man, we're at New Year's season. It's going to be 2024, my friends. It's going to be lit. Woo. And Daniel, Merry Christmas to you and Happy New Year to you, my friend. And same to you. I hope this year is incredible for all of us. It's going to be an interesting year. We're going to be getting through it together, and we're going to come out much, much stronger on the other end of it, no doubt. Good to see you. Thank you, Daniel, for the nice no-no. Tom McSee's here on Locals, says if they decide there is no presidential immunity, can they go back and charge Obama for murder? As far as I know, there isn't a statute of limitations on that. Yeah, it's a good argument. Yeah, it's a good argument. I don't know if is there a federal statute of limitations on that? I don't know. Probably not. And when did that happen? Let's say, 2008. So you give us, let's say, even 20 years. He got in there 2008 and 2012. So if we give it 20 years, which is a long statute of limitations, even if there was a statute of limitations, let's say it's 20 years, we got until 2028 to do it. So maybe Trump will take action on that once he wins. We've got this from Tony. Hey, what's up, Tony? Man, more membos. You are the man. Tony is bringing in Audie, Joe, Ranulf, bringing in Queen B, bringing in CAM, and bringing in Tans in the house, courtesy of Tony Hay Munkets. Tony, thank you for the membos. We got Tanya Karras. What's up, Tanya? Says, it's leftover Taco Tuesday. Does ham go in tacos? Happy holidays, everyone. Thank you, Tanya, for that. So Tanya is our official Taco Tuesday purveyor. And thank you, Tanya, for that one. I think ham, we're going back to the wrap debate. We had a kind of a ham sandwich and wrap debate. Like, here's my question, okay? I like a good ham in a roll, which is what I had last night. What happens if you put the ham on one side of the roll like this, and then you fold it up? Is that a ham taco? I don't know. So you'll have to be the judge of that, my friends. Thank you, Tanya, for the nice dono, and happy Taco Tuesday. Crash is here. What's up, Crash? Says, Maine and Colorado are going to force me to look into in depth if there have been challenges of the full faith and credit clause regarding collateral estoppel. Well, I'm sure there have. I'm sure there have. The question is, who's trying to enforce it and against whom and where on what issues, right? Those are the big issues. And this is like, as we saw in the filing, it's an offensive use. Like Trump is not litigating there. The same party in Colorado is not litigating there. It's another group who's taking that issue that's not even theirs and trying to exercise it against Trump. So it's very aggressive. And the question is that too far? But again, there's no real court here. This is just the Secretary of State who's making this ruling. Good to see you, Crash. We got this one is from Bruce Rice. Says, we love you, Rob. Well, Bruce, I love you back, man. Thanks for being a member. And thanks for the nice dono. I hope you had a beautiful Christmas, my friend. And thanks for being here on this Tuesday back. The NY, the good doctors over on Locals, says saying someone should go to hell isn't a problem. Republicans need to stop navel gazing. Dems are going to say a lot of things. Well, they're indicting people for it. That's my concern, NY. Like, they're putting people in. I agree it's not a problem. Maybe I made too much about that today on the segment, but I'm watching these patterns envelop. I'm watching the FBI saying, it's time to investigate. I'm watching Lisa Monaco saying, it's unprecedented here, and it makes me nervous. So I'm watching this like with a fine-tooth comb because I'm waiting to see what they do with it. They're gonna try to do something. What's up? Eddie Oliver over from Texas says, I thought we agreed we're gonna call him Little Jackie Smith. Was that the official decision, Eddie? There were some really good ones. There was what was another one? Non-special counsel Jack Smith. There were some other pretty good ones that came out. Little Jackie Smith, that's not bad either. Yeah, it's not bad. I think officially it's deranged thug Jack Smith, but Little Jackie Smith is good. Illegitimate Jack Smith, there's a bunch. Eddie, thank you for the nice dono. This old guy's there on Locals says Monaco, Weiss, Smith, and her have all raised discussion of the DOJ to the level of presidential election campaign speech. As far as I'm concerned, Trump's speech is just campaign speech. So, yeah, it kind of depends on what you're talking about. So if you said, this old guy, for example, that his post-election speech was campaign speech, then that would take it outside of the protections of the First Amendment, or take it outside, let me say, of the official acts of the presidency. If you say it's just campaign speech. Now, if you, like for the January 6th stuff. Now, what he's saying now about Jack Smith, I think is campaign speech, but I think it's also American citizen speech. It's like, when you make it political, as we've seen here, it is at the apex of the protection, right? Like, free speech is for politics. It's so that you have a safety valve when you have a tyrannical government that is trying to incriminate you. You need to talk about it so that you can expose it. It's the only way to shine sunlight on it, which is literally why they're trying to gag him. But yeah, it's, you know, and I agree, this old guy, I think they're going to try to limit him while they want to exercise their speech while they limit their opponent's speech. Good comment. Thank you, this old guy. NY says, what is wrong with them not certifying? She didn't say we will get you guns and men. He said we will get you lawyers. We shouldn't legitimize this as a problem. NY says, Trump has a point. Think of all the carbon we can reduce and taxpayer money saved by eliminating all those useless feds and jobs. We can appease the commies by equitably redistributing their stuff. Well, right, I heard Pinochet's helicopter tours. I heard that there were some serious concern. I mean, well, apparently somebody said that human beings are the cause of the planet's demise. We emit CO2. And so I was thinking to myself, what are all the climate people going to do now when they can't breathe? I guess hold their breath or something. I don't know how they breathe, though. Eddie says Karl Rove killed thousands of Americans and millions in the Middle East. There is a reason they don't like us. Mosul and Fallujah are two of them. This, as you know, is coming from a veteran. And more than that, a Texan. That's from Eddie, from the great state of Texas. Our Eddie, our friend Eddie. Thank you for your service, my man. I know that you know this more than a lot of people like myself do. And I agree. You know, I feel what they did after 9/11 was really capitalize on a lot of fear, and there should be accountability for that. NY says it boils down to this: if you support Trump, they think you're a deplorable. Do they expect a handshake afterwards and say good game? We'll see. I'm not expecting that. Tony Hay says, I keep trying to get the demodumps catching on in the chat, but it never happens, and I don't know why, because I think it is awesome. Well, I think you're awesome, Tony Hay Munkets. You're trying to get the Democrats in the chat to buy donos, to invite membos and donos. I'm not sure if that's ever going to happen, but it's a good effort, Tony Hay. We got Waldo. What's up, Waldo? Man, we got new membos. We got Karen E., Merck Co., 3D Slug, Carrie Who Saw What's It, and Augustus Tiberius, all coming in thanks to Waldo. Waldo, thanks for being a membo. Thanks for bringing in 5 new membos. It's a beautiful day. Thanks for doing that. And another one from Tony Hay, bringing in Dust in the Wind, Vegas Woman 702. I know that zip code well. Jackie, we used to get phone calls all the time at our office from 702, and a lot of speeding tickets between Arizona and California, and Vegas. But Gloria B's here, Alan B, all is here, courtesy of Tony Hay. Thank you, Tony Hay. Crash is also over on the locals. Says full faith and credit is not immutable. Surely there have been challenges. I absolutely believe that there have. I just don't know what the lengths are, what the extent of it is. Good to see you, Crash. Hopefully dig in and find something good. We've got Ray K's in the house. What's up, Ray K? Saying, thank you very much for this very nice dono, Ray K. Very generous of you. Says, wishing Rob and all here a blessed Christmas season and safety and hope in the new year. Saying, the Lord bless you and keep you. The Lord make his face shine upon you and be gracious to you. The Lord turn his face towards you and give you peace. Numbers 6 from Ray K in the house. Amen. What a beautiful prayer. Blessings to you, Ray K. I hope you have had an amazing Christmas. New Year's is right around the corner. I know you've been a member for a long time, my friend. 2024 is going to be a lot of fun. We're glad that you're here. Thanks for being so supportive of us over the years. And Happy New Year to you, my friend. Ryan Patrick's in the house. What's up, Ryan Patrick? Says, smash that like button, baby. You heard the man. What's up, Ryan? Hopefully you're having a beautiful day, and Merry Christmas and Happy New Year to you too, my friend. Decia says, can we come up with a bingo card for 2024? Yeah, you know, remember there's that great account called the C-SPAN Review. They were doing the bingo cards for a while. I'm not sure if they're still doing bingo cards. But yeah, what would you put on there? Like, you mean for the channel? Like Jack Smith would be on there. Deranged Thug would be on there. It could be fun. We got this one from Felix, says, wondering why these socialist Democrats are placing all their ballot removal eggs into the 14th. Trump was acquitted through impeachment, and on it does not say a conviction is needed. Aren't they doing the double jeopardy? Yes, Felix, I think it's a great point. Very astute. I think that you're right, exactly right about that. And so if you missed the first segment, at that last, in the first segment, that's a main part of Trump's argument, is saying that he's being prosecuted twice for the same crime. The first prosecution already took place in the Senate. He was impeached, which is like a criminal indictment in the House. Then that went over for the trial in the Senate, and he was acquitted there. And so they can't, for January 6th, like not for some other crime, like for January 6th specifically. Then he was acquitted, and then they just indicted him again because they did not like that outcome. So I think a double jeopardy is actually a great argument. And I was a little bit curious as to why James Trusty was not interested in that take. And so let's say hello to our friends on X before we jump over to our members only after party. We got some good comments on the X platform. Is anybody watching us over there? We got 19 viewers, my friends. 19 viewers on the X. Woo, woo. Good to see you over there. We got Danny McWilliams. We've got, let's see, just a couple here. We got Danny McWilliams says, you break down the law so we all can understand. And thank you. And thank you, Danny McWilliams, for saying that. We try. Darkside says, well, Joe could have just stopped after I can't think. Good comment. George is here and tagging some very nice people saying, hey, thanks for this. Check out Watching the Watchers. Thanks for tagging us, George. Words are free, says Rob. Thanks for bringing the content on Boxing Day. Love your work. Thank you, Words. Old Drill Sergeant's here. And JB Salty Sarge sharing this one from Horatio Walpole, 4th Earl of Orford, says, the world is a comedy to those that think and a tragedy to those that feel. Ooh, that's a powerful quote. Interesting one over there. So, my friends, that's us over on the X platform. So come and join us over there. We also have a watchers community on the X platform where you can connect with other watchers. This is what it looks like if you want to support each other out in the X platform wilderness. Like each other's stuff, retweet each other's stuff, leave comments, get to know each other, because that's what it's all about. Connections. And so, my friends, we are going to leave it there. Head on over to watchingthewatchers.locals.com for our members only after party. We'd love to see you there. Before we wrap, we want to say thanks to our mods. I think Vanticus is on like vacation or something, you know, just enjoying himself. Vacationing. Hope you're enjoying yourself, V. We can't wait for him to get back. V has a new book out, and we'll be sharing more of that. K-Bean, thank you for the dono clipping. Thank you to Just Cause, Playing Hooky, our friend Ronnie Cole, Zulu in the house. We got Beyond Geo, Zach Nichols clipping away hard for us today, along with John Allen. Thank you, gentlemen. Janek and Dog Digger all in the house. And so, my friends, our Meme Smiths, our Geegum Geegum, Nathan N810, and Sleepy Dog Lee. And we're happy to see all of our friends in the house. Tony Hayes bringing in 5 new membos. Matt F, Helium Hub Crypto Collective. Sounds cool. Melanie H, Rodney, and 5280 all coming in. And NY says, those who oppose Biden and support Trump should avoid the minutia arguments and work towards how Trump can be elected legitimately, along with the House and a Senate. The situation has not been so positive for them since Reagan. It also means getting involved locally as a poll watcher. A pair of eyes goes a long way to dissuade shenanigans. Good ideas. Good ideas from NY. And I like that. Yeah, we're going to see what we can do in the next election season, and it's going to be a lot of fun. So, my friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. We would love to see you there. But if we don't, well, we will be back here tomorrow. It's going to be a beautiful Wednesday, and we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Welcome to Rainer J as our newest supporter. Sleep very well. We'll see you right back here tomorrow. Make it a great night, my friends. Bye-bye.